So hello, and thank you for joining us for our 7th Brain Matters, and change my slide here, 7th Brain Matters webinar series. Know Your Rights and Responsibilities, Capacity, Power of Attorney, and Estates with Laura Geddes, John Morrissey, and Susan Wood. My name is Susan Oster, Coordinator, Dementia Friendly Communities with the Alzheimer's Society London and Middlesex. I will be the MC and tech support for today's webinar, and my colleague Dina Boone will be assisting me on the tech end. At the Alzheimer's Society, our role is not only to provide programs and services to people who are going through the journey of dementia, but also to provide dementia education and to advocate for those living with cognitive disabilities. We wanted to recognize the generous support of this webinar by Siskins, and I am pleased to share a special greeting from them. Siskins is a full-service law firm based in London, Ontario, with over 230 lawyers and support staff. Their wills and estate lawyers have the knowledge and expertise to provide strong and effective presentation in will and estate administrative and litigation matters. Siskins is proud to support the Alzheimer's Society's Brain Matters webinar series and hopes the next hour will provide you with some guidance on what to consider when it comes to capacity, power of attorney, and estates. So before we begin, I have a little business to go over relating to the webinar experience. Please note that your cameras are off and microphones are muted for the webinar. This event is being recorded and will be available in the future on our website. And for those who did register, you will get email notification when the webinar is ready. At the end of the presentation, we will have approximately 10 to 15 minutes, we'll see how it goes, for a moderated Q&A. We will do our best to address as many questions as we can. During the presentation, if you have any questions for the presenters, please add them to the Q&A box. If you would like your answer to be, our question to be anonymous, please click the Send Anonymously box before clicking the Send button. If you are having any technical concerns or if you would like to communicate with me, please type in the chat box. You may need to move your cursor around to see the Zoom controls and icons. And again, please note, as I mentioned earlier, you were sent a case study by email in the past few days. The presenters will be using this composite case to facilitate the discussion. If you have not received the case study, please type your email into the chat box and it will be sent to you as soon as possible. So quick disclaimer, since everyone's situation is unique, the information being provided in this presentation is for educational purposes only and not legal advice for your situation. Should you have specific legal questions about your situation, please contact a lawyer for advice. So it is now my pleasure to introduce my colleague and our moderator for today's webinar. Susan Wood has an MSW degree from Western University. She has been a behavioral support social worker with the Alzheimer's Society in London and Middlesex since 2020. In her career, Susan has supported people dealing with many complex, multi-layered situations involving elder abuse, capacity issues, and social determinants of health needs. Susan has liaised with official capacity assessors, the Office of the Public Guardian, and Elder Abuse Ontario to achieve optimal outcomes for families that she has been privileged to support. In her spare time, she enjoys kickboxing, look out, music, and travel. Welcome, Susan.
Thank you very much, Susan. And now it is my great honor to introduce our speakers for today's webinar. Laura Geddes is a lawyer in the Estates Group at Siskins. Laura's practice focuses on estate planning and administration, including the preparation of wills, powers of attorney, and trusts. Outside of work, Laura enjoys reading, playing the violin, and spending time outdoors with her family. John Morrissey is a third-generation lawyer who practices at Siskins in the General Litigation Group. John's practice focuses on all areas of estate and capacity litigation. In his spare time, John enjoys exercising and spending time with his four-legged companion, Walter. To learn more about John and Laura, please refer to the case document sent by email prior to the webinar. At this time, I would like to introduce our case study about Gloria. Please note, this case was designed to highlight as many examples and legal principles as possible in a limited amount of time, and the case itself is not a real situation, although we know it could be. Meet Gloria. Gloria is 85 years old and resides alone in her home in London, Ontario. Gloria's husband, Robert, died several years ago. Since Robert's death, Gloria has become increasingly reliant on her 3 adult daughters, Courtney, Robin, and Catherine, and also on her granddaughter, Claire, to assist with chores around the house. She also relies on her daughters and granddaughter to take her shopping, to take her to the bank, and to take her to medical appointments because she is no longer able to drive on her own. While Gloria loves her daughters deeply, she has a special bond with her granddaughter, Claire, who visited with her often, almost on a daily basis, to play card games and help with crossword puzzles. Gloria jokingly referred to Claire as her 4th and favorite daughter. As Gloria's health began to deteriorate and her care needs increased, her daughters discussed the possibility of moving her into a long-term care home, where they were confident that she would receive the type of care she deserved. However, they were hesitant to make any suggestions in this regard because Gloria remained capable of making decisions and remained adamant that she continue to live in her own home until she died. In the fall of 2018, Gloria's daughters noticed that she was becoming increasingly forgetful. She had difficulties finding words, remembering names, and she began encountering difficulties with reading and writing. This concerned her daughters, as reading was one of Gloria's favorite hobbies. Gloria also felt that something wasn't right. She didn't feel like herself. The lawyer meeting. It was around this time that Gloria's daughters recommended that she schedule an appointment with a lawyer to discuss matters relating to her powers of attorney and her will. Although Gloria already had powers of attorney, those documents were outdated as both named attorneys had died. Her daughters were also surprised to learn that Gloria didn't have a will. Accordingly, Gloria scheduled an appointment with her lawyer, Mr. Jones, to determine whether it was appropriate to have new powers of attorney drawn up and to make a will. When she met with Mr. Jones, Gloria had the following question. Laura, what is the purpose of a will?
Thanks, Susan. So the purpose of a will is an important estate planning document, and it will name a person to be responsible for the administration of the estate. So that is the executor or the estate trustee. We use those terms pretty interchangeably now. That person will be responsible for locating assets, making sure that debts and final taxes are paid, and following the instructions in the document. So the will also sets out instructions on how the estate is to be distributed and who should benefit from the estate. So for this example, Gloria might do up a fairly simple will that names one or more of her daughters as the estate trustee and then divides her estate likely in equal shares between her 3 daughters.
Okay, thank you. Dawn, what happens if Gloria dies without a will?
Susan, if you die without a will, you are said to have died intestate, and the administration of your estate is governed by Ontario's intestacy laws, which can be found in various pieces of legislation, including a piece of legislation known as the Succession Law Reform Act. Contrary to popular belief, if you reside in Ontario and you die without a will, your property does not automatically go to the government. Instead, Ontario's intestacy laws dictate who will benefit from your estate and to what extent after the deceased's debts and liabilities have been paid. Ontario's intestacy laws also dictate the procedure to be followed when that person dies without a will, including but not limited to who may apply to the court to be appointed as the estate trustee and what requirements must be satisfied in order for someone to be appointed as the estate trustee. With an intestacy, there are extra steps involved in the administration of the estate. There can be extra costs, and there's the increased possibility of conflict. So in this case, if Gloria died without a will, and given that her husband, Robert, has already died, Gloria's 3 daughters would be the sole beneficiaries of her estate, and her 3 daughters would be equally entitled to apply to the court to be appointed as the estate trustees of her estate.
Thank you. What are powers of attorney? And is there more than one kind, Laura?
Yes, so powers of attorney are the documents that specify the person who would make decisions on your behalf if you became incapable of making those decisions for yourself. So that person is referred to as an attorney. They don't have to be a lawyer, so it's not attorney in the American legal sense. Or they're also called the substitute decision maker. So someone who's going to step in and make a decision for you if you can't. There are two types of powers of attorney. There's the power of attorney for property. So this covers property in a broad sense. So it includes all assets that you have and covers decisions related to real estate, bank accounts, investments, personal property, pretty much anything that a person owns. And then there's the power of attorney for personal care. So this is the one that most people think of as being healthcare decision making. So it does include consent to and refusal of treatment. But it also includes decisions that are broader than that. So about your living situation, safety matters, hygiene, and any other matter of personal care that the individual can't make the decision for themselves.
Okay, and what happens if I don't have a power of attorney in place, John?
Well, if you don't have powers of attorney in place and something happens to you that results in you becoming incapable of making decisions regarding your property and or your personal care, it may become necessary for someone to apply to the court to be appointed as your guardian to allow that person to make decisions on your behalf. And people often get confused about the difference between an attorney and a guardian. Well, the duties and responsibilities of a guardian are largely identical to the duties and responsibilities of an attorney. The main difference between a guardian and an attorney is that a guardian is appointed by the court to manage an incapable person's affairs, whereas an attorney is chosen by the person who is granting the powers of attorney. So, in this example, let's assume that one of Gloria's GICs is set to mature in a few weeks, and that she will need to provide instructions to the bank as to what to do with the GIC. Does she roll it over? Does she buy another investment? Does she cash it in? Well, if Gloria doesn't have powers of attorney in place and it's apparent to the bank that Gloria is not able to understand information that is relevant to making decisions regarding her GIC, the bank very well may refuse to take Gloria's instructions, and it will most certainly refuse to take Gloria's daughter's instructions. In order to deal with Gloria's GIC, someone would have to apply to the court to become Gloria's guardian in order to have the legal authority to make that decision for Gloria.
That's an important distinction. Thank you for that, John. Can you tell me what the duties and responsibilities of an attorney for property are, Laura?
Yes, so an attorney for property has a number of duties and responsibilities to the person for whom they're making decisions. So they always must be acting in that person's best interests. They have to put the incapable person's needs ahead of their own and avoid any conflicts of interest. So avoid selling property to themselves, for example. They have to act honestly and diligently and in good faith, and they must manage the finances in a way that is consistent with the decisions that the now incapable person made while they were capable. And they also need to be consistent with what the person who's making decisions about personal care is doing and work with that person. And they have to explain their powers and duties and what they're doing to the incapable person and involve them in that conversation to the extent that they're able to be involved in that. And consult as well with other supportive friends and family members of the incapable person. And one of the most important aspects that can come back later is they must keep detailed records of everything that they do with the incapable person's property. So they may at some point have to account for their dealings with the property. So they need to be very careful about knowing where everything has gone and what's been done.
Okay. And can you tell me what the duties and responsibilities of an attorney for personal care are, Laura?
So many of these are largely similar to the responsibilities of the attorney for property. They also need to act honestly, diligently, and in good faith. They also need to attempt to involve the incapable person in the decisions that are being made to the extent that that's possible. They need to as well respect the known wishes of that person. So if there was something that was expressed as a wish while the person was capable, then they should be trying to carry that out to the extent that that's reasonably possible in the circumstances to do. If they can't do that or they don't know of a known wish about any particular decision, they should be acting in a way that considers the incapable person's values and preferences. And they need to choose the least restrictive and intrusive course of action that's available and appropriate in the circumstances. And again, similar to the power of attorney for property, they need to be fostering contact between supportive friends and family members and consult with those individuals in making their decisions. And finally, just to note, there's sometimes some confusion about this, but their role is really about arranging care for the incapable person and making sure that their personal care needs are met, not necessarily being the person to provide that care on a daily basis to the incapable person.
That's good to know. How often should I update my wills and power of attorney, Laura?
So it's a really good idea to review your copy every few years. If you do a will with a lawyer, most of the time they're going to give you at least a copy of it. It doesn't mean you need to meet with your lawyer that often, but just have a read through it, make sure that it's still appropriate for your situation and you're still happy with the way everything is set up. Otherwise, major life events are really good times to do an update. Births, deaths, marriages, separations, and divorces are really key points in people's lives where you might be looking at that. Also, if you acquire property that's located outside of Canada, or you acquire something that you want to deal with in a specific way or leave to a specific person, then that's a good time for an update.
That's really good advice. John, how should I choose who should be my attorneys?
Well, choosing who to appoint as your attorney is an incredibly important decision. And it's a decision that the grantor should make, and the grantor alone, without influence from anyone else. When you choose your attorney, you are choosing the person or persons who you want to be making decisions on your behalf if and when you become incapable of making decisions yourself. So in making the decision, you should choose someone who you know well, someone you are comfortable with, someone who you can trust, who's reliable, responsible, and you know who will act in your best interests. Using the example of Gloria, if she had concerns that one of her daughters is not very good with money or becomes easily overwhelmed in stressful situations, perhaps it would not be a wise idea to appoint that daughter as her attorney for property or personal care. On a similar note, if one of Gloria's daughters is terrible with money and finances, but is very compassionate and patient and loving, perhaps Gloria would name that daughter as the power of attorney for personal care, but not as the power of attorney for property.
Okay. Can I choose more than one attorney, Laura?
You certainly can. So there's a few options. You can have more than one person acting, and then you can appoint people who will be acting together. So you can require them to act jointly, meaning that all decisions need to be agreed upon between them. And if there's anything that needs to be signed, for example, to give effect to that decision, they all must sign that document. You could name them jointly and severally, which means any one of those individuals has equal authority to act, and they don't need the others to sign off on their decisions. And you could also have different people in the different roles. So you don't need to have the same people being the attorneys for property and the attorney for personal care. So as John said, if there's different people in your lives with different strengths, you can choose accordingly.
Okay, John, the next two are for you. Should I appoint a substitute attorney and why? And can someone refuse to be my attorney?
Yeah. So it's always advisable to appoint a substitute attorney when providing instructions to the lawyer preparing your power of attorney documents. And this is because any number of events could occur that would make it impossible or impractical for the primary attorney to act. So for example, the primary attorney could die. The primary attorney could become incapable themselves such that they cannot make decisions for you, or the primary attorney may simply decide that they do not want to be your attorney. If you only appoint one attorney and that attorney is not prepared to act, it will be almost like you don't have powers of attorney in place. And if you become incapable and can no longer make powers of attorney, someone will need to apply to the court to become your guardian. To the second question, the answer to this question is yes. Your attorney can refuse to act. There are no laws or regulations requiring a person named as attorney to accept the position, and for good reason. Being an attorney for property or for personal care has the propensity of being a difficult role to fulfill. It takes time, it takes effort and dedication. Further, depending on the dynamics of the family, attorneys' actions are often scrutinized, sometimes criticized. Being an attorney can be a thankless job. This is why it's important that you choose someone who you know is prepared to act, and why it's also important to appoint a substitute just in case.
Okay, and what are the pros and cons of having more than one attorney, Laura?
So it can be a good control for the possible misuse of the power. So you can imagine that, particularly with a power of attorney for property, that person has access to all of your banking, and there's the potential that funds could be misused. So having more than one set of eyes on things can be a little bit of a control on that. However, having multiple people who need to work together, depending on their personalities and their dynamics, that can give rise to problems if they can't agree. And the jointly and severally option that I mentioned before provides some flexibility if one attorney is temporarily unavailable, for example, but again, it can give rise to problems if they do not agree and they're working at cross purposes and they're sort of changing things back and forth. That can result in some difficulties.
Okay, and do the attorneys need to consult with me with respect to decisions being made, John?
Well, to the extent that it is possible, attorneys should always consult with the person who gave the power of attorney. So in this case, Gloria, with respect to any decisions being made on that person's behalf. Gloria's attorney or guardian have a duty to ascertain what her wishes are and have a statutory duty to encourage Gloria to participate in decisions being made. Now, this doesn't necessarily mean that an attorney or a guardian must do what the incapable person is asking them to do if what is being asked is not in that person's best interest, but it does mean that the attorney or guardian need to consult with the incapable person, consider what their wishes are, and encourage that person to participate. So, using Gloria as an example, if her 3 daughters are acting as her attorneys and are trying to determine which long-term care home Gloria will reside in, they have a duty to consult with Gloria and to encourage her participation. As much as possible, Gloria should be involved in the process, whether that means Gloria being present when Gloria's daughters visit the various nursing homes, reviewing brochures and online reviews about a given long-term care home, and asking questions like, what do you think about this home? What do you like about this home? What don't you like about this home? These are the type of questions that Gloria's daughters should be and would be expected to ask her.
Absolutely. What if I'm unable to express my wishes and preferences with respect to a given decision, Laura?
So if that occurs, then the attorney should be considering whether there's a prior known wish. So sometimes people will write out their wishes and preferences in a separate document, for example. Sometimes they'll write a letter to their attorneys that indicates what they might want in certain situations. If not, then the attorney has to make a decision that is guided by what is in the person's best interest. And that involves a consideration of their values and beliefs of the incapable person and the impact that the decision would have on their quality of life, as well as weighing the benefit from making that decision against the potential harm or benefits from any alternative decisions that could be made.
Okay, and John, is it possible for my attorney to take advantage of their position to my detriment?
Unfortunately, the answer to this question is yes. It is possible for an attorney to take advantage of their position as your attorney. And I see this in my practice all the time with powers of attorney for property, where unscrupulous and dishonest attorneys take advantage of their elderly parents or family members by draining bank accounts, cashing in investments, transferring properties, selling homes. The list goes on. It's very important to know that when a power of attorney for property is activated, which usually occurs when someone is declared incapable of managing their property, the attorney acting pursuant to that document can essentially do whatever the incapable person could do with their property if they were capable. which again is why it's so incredibly important that you choose someone who you trust to be your attorney.
I have been encountering some issues with my memory. Does this mean I don't have capacity to make a new will and powers of attorney, John?
No. So just because someone is encountering cognitive difficulties does not automatically make that person incapable of making a new will or powers of attorney. Capacity is time and task specific. This means that you may be capable of making a will in the morning, but not in the afternoon. You may be capable of making a power of attorney for personal care, but not a power of attorney for property. There are different degrees of capacity required for making a will versus making a power of attorney for property versus making a power of attorney for personal care. If you are encountering memory issues or cognitive difficulties, or you've been diagnosed with dementia, but do not have a will and powers of attorney in place, the best thing you can do is to address the issue immediately by meeting with a lawyer to discuss your options.
Thank you. How will my attorneys know when it is time for them to begin acting for me, Laura?
So that's a great question, and I get this one all the time. So sometimes the trigger for the document to start being used is built into the document itself, such as when there needs to be a finding of a lack of capacity in order for the document to be used. Sometimes capacity is very clearly changed from one day to the next. So someone who has been in an accident or has had a stroke or something like that. And in many cases, though, it's a gradual slide where the attorney named in the document begins to assist more and more on a daily basis. This can be a real gray area, and depending on the circumstances, there may be cases where it's best to have capacity assessed if possible.
Okay, and Laura, I only want my attorneys to begin acting when it is determined that I can no longer make decisions regarding my property and personal care by someone who is authorized to do so. Can you include a provision in the document to this effect?
Yes, you certainly can. So the personal care power of attorney already has this built in to a certain extent. The ability of the attorney to make a personal care decision for you really depends on an inability to make that decision for yourself. So that person will only be turned to if, for example, a medical professional determines that they can't get instructions from the person themselves. And for property, this is a different form of power of attorney, which is known as a springing power of attorney. Most of the powers of attorney for property that we do are called continuing powers of attorney. So they can be used immediately upon being signed, and they last through any subsequent incapacity. When they're originally signed, the person can only act on express directions from the grantor of the document. The springing power of attorney would state that it only comes into effect on a certain provision. So most commonly, that's some kind of finding that the grantor no longer has capacity. The downsides of that are you have to wait for the assessment to happen, and it is not usable if, for example, the grantor is still mentally capable, but for some reason needs the assistance of the attorney, whether that is because they are absent from the country or they are mentally capable but physically unable to go to meetings at the bank, for example.
Okay, thank you so much. After answering her questions, Mr. Jones, who had been assisting Gloria with her legal matters over the last 30 years, met with her, took her instructions, and prepared the new power of attorney document. Gloria decided to appoint her 3 daughters as her attorneys. She appointed her granddaughter, Claire, as a substitute attorney. Gloria's diagnosis. For the next year, Gloria carried on as usual, celebrating birthdays and holidays and spending time with her children and grandchildren. Unfortunately, Gloria continued to struggle with memory issues, and she would often become confused when visiting with her daughters. In December of 2019, Gloria scheduled a doctor's appointment and asked her 3 daughters to attend the appointment with her. Although she felt that she was still capable of making decisions for herself, she wanted her daughters to come to the appointment because she had named them as her attorneys for personal care and knew that in the future they would be called upon to make decisions regarding her personal care. During the appointment, Gloria's doctor did some basic cognitive testing and referred her to a geriatrician for further evaluation. In January of 2020, Gloria was diagnosed with mild cognitive impairment. Although she was quite functional, her ability to understand her finances and the consequences of a decision or a lack of decision was becoming increasingly impaired. Gloria's daughters worried for their mother's safety. Accordingly, Gloria scheduled a follow-up appointment with the geriatrician to determine if it was time that her daughters began helping her make decisions about her property and personal care. The geriatrician advised her that her illness had progressed and it likely would be appropriate for her daughters to begin acting as her powers of attorney. He provided Gloria with a doctor's note outlining her diagnosis and prognosis, but he refused to provide a letter outlining his opinion on whether Gloria had capacity to make decisions regarding her property and personal care, advising that he did not have the authority to make such a determination. Instead, the doctor instructed Gloria and her daughters to obtain a report from a capacity assessor to confirm whether she was capable of making decisions regarding her property and personal care. The fact that the daughter would not provide an opinion regarding Gloria's capacity surprised her daughters. Puzzled, the daughters set up a meeting with a lawyer to find out more about capacity assessments. During the appointment at the lawyer's office, the following questions were asked. John, why won't the doctor provide us with an opinion regarding Mom's capacity?
Well, although medical records are of assistance in determining whether a person has capacity to manage their property or their personal care, or whether a person has the capacity to grant powers of attorney, the question of whether a person has capacity to do these tasks is a legal determination. And for this reason, doctors are often reluctant or refuse to provide an opinion regarding capacity. If a doctor does provide an opinion regarding a person's capacity, which happens from time to time, that opinion may be subject to scrutiny, and that doctor might be called as a witness on a matter that technically that doctor should not be providing an opinion on. More often than not, healthcare providers will not provide an opinion regarding capacity, and they will specifically tell you to proceed with a capacity assessment.
So that begs the question, John, what is a capacity assessment?
Now, Ontario's Ministry of the Attorney General describes capacity assessments as a formal assessment of a person's mental capacity to make decisions about property and personal care. Capacity assessments are conducted by specially qualified assessors, known as capacity assessors, who must follow specific guidelines. The assessor meets with the person whose capacity is being assessed and asks them a series of questions to determine if the person has capacity. The questions the assessor will ask will be based on the type of capacity the assessor is assessing. Under the Substitute Decisions Act, an assessor can assess a person's ability to manage their property, their capacity to manage their personal care, and their capacity to grant and or revoke powers of attorney for property and personal care. These capacity assessments can be very helpful in fending off will challenges and power of attorney challenges, and are often recommended by lawyers or are ordered by the court if there are any issues regarding a person's capacity.
Does Mom have to participate in the capacity assessment, Laura?
No, at this stage, her participation is voluntary. So prior to starting the assessment, the assessor will explain the purpose and the possible ramifications of the assessment, including the possibility that there might be a finding of incapacity, and will obtain Mom's consent to proceed.
What if Mom refuses to participate in the capacity assessment, John?
Well, if Mom refuses to participate in the capacity assessment, then the assessor cannot perform the assessment. And this is actually set out in the Substitute Decisions Act. If Gloria does not want to participate, she does not have to, and a lot of people have a difficult time understanding this. The only way to force someone to undergo an assessment is to commence a court proceeding alleging that Gloria is incapable of managing her property and asking the court to order Gloria to undergo a capacity assessment. Ordering someone to undergo a capacity assessment is an intrusive process, and courts are often reluctant to make such orders. If, however, the court is satisfied that there are some reasonable grounds to believe that the person is incapable, the court may order that the person be assessed.
Who conducts the capacity assessment and what qualifications must they have, Laura?
So a capacity assessment is conducted by a qualified capacity assessor. So this person is usually a healthcare professional, such as a nurse, a social worker, or a doctor, who has undergone the necessary additional training and completed courses necessary to be certified by the provincial government as a capacity assessor. So they will have an in-depth understanding of the various legal requirements that John has mentioned for capacity.
And John, how do we find a capacity assessor?
Yeah, so the Ministry of the Attorney General maintains through the Capacity Assessment Office a roster of qualified assessors. All you need to do is go on the internet or call the Capacity Assessment Office, and they will send you a list of assessors in your region, or you can go online and you can locate the assessors who are in your region who may be able to assist.
Okay, and I see that Susan has actually just posted that in our chat box, the way to get the capacity assessment list. Laura, how much does a capacity assessment cost?
So prices can vary from assessor to assessor and depend on the situation. Usually the assessor is going to have an hourly rate that they'll charge. Often, most end up somewhere between the $500 to $1,000 rate, but it really depends on the complexity of the matter. There may be travel costs involved for the assessor. They may want to interview additional people to gather background information. So it might be a good idea to ask for an estimate once the assessor has some information about the case.
Okay, thank you. John, do we even need a capacity assessment?
Well, unless a court orders that someone undergo a capacity assessment, you do not need a capacity assessment. However, capacity assessments can be useful in situations where a lawyer is being asked to prepare power of attorney documents, but he or she is uncertain as to whether that person has capacity. An assessment confirming capacity will allow the lawyer to confidently prepare the documents. An assessment can also be helpful in fending off challenges that a person did not have capacity to make a power of attorney. If the capacity assessment was conducted around the same time that the powers of attorney documents were executed, and the assessment reveals that the person did in fact have capacity, the report arising from the assessment could be a useful tool in responding to any challenges to that document.
Excellent, thank you. In the interest of time for the next section regarding Gloria's capacity assessment, I'm going to do a bit of paraphrasing instead of reading word for word. We want to make sure that we leave time to answer specific questions that are asked. So the next section of the case study really deals with Gloria and her family obtaining a capacity assessment. They go to the bank and present the power of attorney documents. Some of the banks are a little bit more challenging in terms of accepting the documents. And so I'm going to go straight to the questions that have been prepared. During the meeting, Gloria's daughters asked the following questions of the lawyer. Why is the bank asking our mom to sign another power of attorney? She has already prepared one, Laura.
Yes, so this is happening more and more frequently where banks have their own form of power of attorney document. It may be part of their routine process to get that form signed. Some banks are becoming more concerned about potentially fraudulent powers of attorney, particularly during COVID now, where more documents are being signed remotely rather than in person.
And should Gloria sign the documents, Laura?
So my opinion would be that she should not sign it without having it reviewed by her lawyer. In many cases, the signing of a new power of attorney is going to revoke prior made powers of attorney, unless it has very specific wording that prevents that from happening. So also in this case as well, given that the capacity assessment has happened, it may well be that she lacks the capacity to sign a new power of attorney document, which could lead to a whole bunch of problems. So no, I would say not to sign it without having some advice on that.
Okay. What are the potential consequences and risks of our mom signing another power of attorney prepared by the bank, Laura?
Yes, so the big risk is that it would revoke the power of attorney that she had previously planned with her lawyer.
And what if Gloria refuses to sign the bank forms? What other options does she have, Laura?
So if her powers of attorney that she has presented to the bank meet all the legal requirements that you need for a power of attorney under the Substitute Decisions Act, so it's witnessed properly, it has the right number of witnesses, the bank cannot legally refuse to accept it. So occasionally the lawyer who prepared the powers of attorney may need to write to the bank. So I've done that on occasion to escalate it. So she could ask her lawyer to do so, or she could try to escalate it herself within the bank so that the issue gets sent to their legal department. Aside from the capacity issue, certainly if she was going to sign it, it would be appropriate for her to take it to her lawyer first.
Okay, thank you. In the next section of the case study, we begin to look at safety concerns arising. So Gloria continues to live in her own home. Her daughters visit more often. Personal support workers begin attending. But then, unfortunately, we notice that Claire, the granddaughter, begins to spend longer periods of time with Gloria. Sometimes she's staying at the house for 3 to 4 weeks at a time, and even bringing her boyfriend to live on a full-time basis. Her daughters don't think that this is a good idea. By April of 2021, Gloria's cognitive health had deteriorated significantly. On a couple of occasions, Gloria was found wandering through her neighborhood in the middle of the night, lost. On another occasion, Gloria had been tricked into providing her credit card information in a telephone scam, resulting in a $5,000 charge on her credit card. A door-to-door salesperson also convinced Gloria to buy an expensive water softener system at a cost of $10,000. Gloria's daughters are increasingly concerned about their mother's safety and whether it made sense for Gloria to continue living on her own. They met with a lawyer and considered the following issues. John, how do we deal with the contract that our mother entered into for a water softener and filtration system? She signed that contract 2 days ago, and we think she was taken advantage of because she already has a water softener system. Can we cancel this contract?
So this door-to-door sales issue happens all the time, and it may be possible to cancel the contract. There are various consumer protection laws in Ontario, as well as basic principles of contract law that could help Gloria's daughters get Gloria out of the contract. Generally speaking, an incapable person should not be responsible for a contract that he or she signed while incapable. It's possible to have a court declare that the contract is null and void. The smartest course of action that Gloria's daughters can take is to immediately seek legal advice to address the issue. Timing is critical, especially when it comes to consumer protection laws and commencing court proceedings to have the contract declared null and void. The longer you wait, the harder it will be to set that contract aside.
Okay, thank you. What's the best way to raise our concerns regarding our mother's safety and care with her moving forward? Should we consult with her, Laura?
Yes, the consultation is really important to the extent that Gloria is able to participate in that process. Open communication about concerns is often key. Of course, this will depend on the family dynamics to some extent. Our recommendation is always, if families can be, to be communicative with one another, can help head off a lot of concerns and problems. Sometimes if there's a resistance to the family members communicating or expressing concerns, they could engage with others whose advice and opinion that Gloria might respect to help relay safety concerns. So other supportive friends, a religious advisor, a healthcare professional, somebody that she has respect for.
Okay, and the last section of this very comprehensive case study includes new powers of attorney. Gloria's daughters then meet with her to discuss their concerns and to canvass alternative living arrangements, including admission into a long-term care home nearby. Gloria knew that this would be a difficult meeting and insisted that her granddaughter Claire be present for support. During the course of the meeting, Gloria's daughters each expressed their concerns and suggested that Gloria take up residence in a long-term care home. Although Claire continued to suggest that she could move in to care for Gloria, by the end of the meeting, Gloria was excited about the prospect of becoming a resident at a nearby care home and agreed that her daughters should begin a long-term care application process. However, several days later, Gloria's daughters were surprised to learn that she had changed her mind. She no longer wanted to take up residence in a long-term care home, and she didn't like the fact that her daughters suggested that she couldn't live on her own. When Gloria's daughters asked her what had caused her to change her mind, she indicated that she didn't have to tell them. She knew what they were up to and that they were just trying to steal her money. Approximately 1 week later, the daughters each received a letter from a lawyer from Windsor stating that the powers of attorney had been revoked and that Claire was now Gloria's new attorney for property. The letter demanded that Gloria's daughters stay away from her and that her home or police would, stay away from her and her home or the police would be called. A copy of Gloria's new powers of attorney were included with the lawyer's letter, and it became evident that a lawyer in Windsor had prepared the document. The daughters knew that Gloria didn't drive, and they also knew that Claire's boyfriend lived in Windsor. Gloria's daughters attended at the home to confront their mom about this change and were met by Claire. They noticed a brand new car in the driveway, and Claire was sporting a shiny diamond ring and necklace. They noticed an apparently distraught Gloria in the background. Usually very put together, Gloria's appearance was disheveled. The daughters confronted Claire about the letter and asked her why she had taken Gloria to a law office in Windsor when she has a lawyer in London. They also accused Claire of taking money from Gloria and asserted that Gloria needed proper care, at which point Claire slammed the door, shouting that if they returned again, she would call the police. After the confrontation with granddaughter Claire, Gloria's daughters scheduled a meeting with the lawyer to receive advice and to get answers to the following questions. We are concerned that our mother is being taken advantage of financially. Does Claire have an obligation to keep track of what it is she is spending on our mother's money, Laura?
Yes, absolutely. So if she is acting as the attorney for property, Claire has a duty to account for all of her dealings with Gloria's property. So she is required to keep records of every single transaction, and she should be able to clearly show where any of Gloria's money or property has gone.
If Claire is taking advantage of our mother, is there a way we can force her to account for what she has done, John?
Yes, if Gloria's daughters suspect that Claire is taking financial advantage of their mother, they can commence a court proceeding to request that Claire account for her dealings with Gloria's property. However, these requests are not automatically granted by the court. Here, Gloria's daughters would need to point to some evidence to cause a court to order Claire to account for what she has done with Gloria's property. If a court does order Claire to account for what she has done with Gloria's property and has determined that Claire has misappropriated money from Gloria, a court might order that Claire be removed as Gloria's attorney and that she be required to return any money that the court determines she has misappropriated.
Okay. And based on the assessor's report, we don't think our mother had the capacity to make new powers of attorney. Is there a way that we can challenge our mother's new powers of attorney, John?
Absolutely. If Gloria's daughters do not think that the powers of attorney are valid, they can commence a court proceeding to request that the powers of attorney be declared invalid. And the capacity assessment that we dealt with earlier would be incredibly helpful in proving their case. Capacity issues aside, if Gloria's daughters think that Claire is not fulfilling her duties and obligations as Gloria's attorney, whether it relates to Gloria's finances or to Gloria's personal care, her daughters can commence a court proceeding to ask that Claire be removed as Gloria's attorney. A court will require clear evidence of misconduct before it will remove Claire.
Thank you very much. That was a really, really good case study and full of information and details. We really appreciate that. The last two slides are actually based about how your social worker can help you. So we have a full roster of social workers at the Alzheimer's Society who assist people with advocacy and support, with home and community care, lawyers, Office of the Public Guardian. We provide education and support around POA. We can provide links and resources for power of attorney. I just wanted to highlight that you can get the power of attorney document online. We also have bound copies at the Alzheimer's Society. So if that's something that you would appreciate having, just let us know and we'll send that out to you. As well, I noticed in the chat box, someone had asked, what about people who financially are unable to access legal help? And I'm sure John and Laura can speak to that as well. One resource that we liaise with quite often is called the Advocacy Center for the Elderly, and it is a community-based legal clinic for low-income seniors that specialize in the legal problems of seniors. The other helpful resource is if you do feel that someone is being taken advantage of with their power of attorney or estate, you can always call the investigations branch of the Office of the Public Guardian. And now we do have about 10 minutes left for questions, and I understand that John and Laura are happy to stay on longer if we need, and to follow up after the fact as well. So I will pass it over to Susan Oster and Dina to go over the questions.
Great, thanks very much. So we have a lot of questions. So I appreciate that everyone has agreed to stay on a bit longer to answer them. And again, this is being recorded. So if you do have to jump off, these will be captured in the recording. So there's a question about contesting a will. So, you know, what is the process for doing that?
I can answer that. So contesting a will is it's a very difficult exercise, and the basis on which you can contest the validity of a will is either the person who made the will, the testator, Gloria in this case, didn't have capacity at the time she made the will, or she was unduly influenced. Someone convinced her to change her will against her wishes, and she felt that she did not have the ability to stand up to that person. And so sometimes when there's relationships of dependency, and you have an elderly parent who lives with their adult child, and the parent is entirely reliant on that child, situations like that, we could see that child influencing the parent into changing their will. To challenge the will, it's a time-sensitive matter. And so once you know that something might not be right, you should be contacting a lawyer. Essentially what happens is you commence a court proceeding, asking the court to declare that the will is invalid, and you're going to have to marshal in, you're going to have to bring in some pretty solid evidence to substantiate your case, whether it's medical records or testimony from witnesses. It's a long process, it's an expensive process, but it's not a process you should shy away from if in fact you think that the will is invalid.
And I'll just add to that, just so that it's very clear, the will only is valid from the date of death of the person who made it. So the process for contesting the will cannot begin until that person has passed away. So you can't try to set someone's will aside while they are still living.
Okay, thanks to you both, and thanks for that clarification, Laura. Just a note for those who have asked questions, I am going to, dismiss the questions just so that they're not seen again, because some people are asking some things that might be a bit personal or identifying. So if you don't see your question pop up in the answered box, that's the reason why. So the next question, if my husband has early onset dementia, should I have my power of attorney and power of attorney for care changed?
I can answer that one. So to the extent that your documents name him as your substitute decision maker, that might be a good time to review, because he might not be at the time that you need the assistance in the position to make a decision on your behalf. If you're asking about his documents, certainly if he's in the early stages, it's likely not too late for him to be making his own planning decisions, and that should be reviewed as soon as possible.
Great, thank you. Next question, we own shares together in our family business. What would be the next step?
Well, that's going to depend on, so if you own shares together, again, the smartest thing to do would be to see a lawyer. The lawyer is going to want to look over all the corporate documents. He's going to want to see what's included in the corporation's minute book, whether or not there's any agreements that might impact what will happen to those shares upon the person passing away. And so it's difficult to answer that question without having a bit more context. But I would say if there are any concerns with cognitive issues and ownership of property, the smartest thing to do is just to go see a lawyer, and that lawyer will be able to review everything and point you in the right direction.
Great, thank you. The next question, are there any legal complications with dementia and medical insurance?
I'm not sure that we would be in a position to answer that in terms of, I'm not sure what the question is asking, if it's asking in terms of qualifying for medical insurance or accessing already qualified
Okay.
medical insurance. Do you have any thoughts, John? I'm not sure that that is a lawyer question. It may be a insurance broker
Yeah,
question.
I agree. I think we need a bit more detail, and we'd maybe have to see a policy of insurance if there is such one. But yeah, I think we need a bit more detail to answer that question.
And
Right.
certainly if there's an insurance claim that's been denied, there are lawyers who specialize in contesting that.
Okay, so if that individual does wish to resubmit the question with a bit more context, that would be great. We'll try to cycle back to it. The next question, how do we handle estate issues with a parent having dementia?
So I can answer that one. So I mean, estate issues, it's kind of it's a broad question, but I mean, essentially what the answers that Laura and I provided in today's presentation is what we would recommend. We'd recommend that a meeting be scheduled with a lawyer of your choosing, explain what the issue might be, and then that lawyer will be able to point you in the right direction. So on this question, it's unclear whether or not if the person has powers of attorney, whether or not they have a will, because the advice the lawyer is going to give is going to largely depend on the facts of that specific case. But the easy and simple answer is meet with a lawyer, describe the issue, and again, that lawyer should be able to point you in the right direction.
Great, thank you. So the next question, if someone is named in the will who is not family and possibly has negative intentions, can that person attest the will?
So I'm not sure. So if someone's named in the will as a beneficiary, for example, absent a challenge to the will, there's not really much you can do. If the testator wanted to include that one brother and sister who might be estranged from everyone else, well, that's the testator's decision to make. That's the person who's making the will's decision to make, and they can give their money away and their estate away however they wish, even if some of the other beneficiaries don't agree with it. So again, absent a challenge to the will, there's not really anything that you can do in that situation.
Okay, thank you. Okay, so I think we might have addressed this one about banks requiring their own documents. I think we've covered that, so I'm gonna move past that one for right now. So what are my rights when my spouse who has dementia refuses to the house that we are in, no longer able to live in the home? I have disabilities myself. So I'm not quite sure. Sorry, when my spouse refuses to all the house when we are no longer able to live in the home. So I'm not sure, there's just a typo there, but perhaps.
I think it means sell the house. Sell
the house, okay.
Mm-hmm. Yeah, that's what I would do. And again, it depends, is there a power of attorney in place? Like the best course of action, I think, would be if the local health integration network, the LIN, isn't already involved, to get the LIN involved. The LIN can be very helpful in sorting out these issues. They can assess the accessibility to the home. They can assess whether or not a person is capable of living in that home and whether their care needs are being met. So my advice, my initial advice would be speak with the LIN and see if the LIN can offer you any guidance in terms of how to move forward. And if you have no success there, you can always meet with a lawyer and see whether or not you should be applying to the court to have capacity assessed, or whether or not you should be applying to the court for guardianship if there's no power of attorney.
Okay, thank you. Okay, and thanks for Susan for helping me with that. And I think we might have covered this, but just maybe clarify the difference between substitute decision maker and POA, because we hear those words kind of interchanged.
Sure. So the substitute decision maker, we used kind of two words interchangeably today. One is the attorney. So that's the person named to make a decision in the power of attorney document. The word substitute decision maker, an attorney is a type of substitute decision maker. So they are a person who would step in and make a decision on your behalf if you could not. There are a couple of other ways that a substitute decision maker might be appointed. So the guardianship process, a guardian is also a type of substitute decision maker. If you did not have a power of attorney and it was a healthcare decision, there's a list in the Healthcare Consent Act of people who can make decisions for you. So that can be a spouse or a child, depending on who is available and how the hierarchy works. That person in that context would also be a substitute decision maker.
Great, thank you. So the next question, are joint banking accounts frozen upon death of a spouse?
So that depends on the circumstances. I've had files in my practice where a bank will freeze a bank account, but it's usually because there are issues surrounding that bank account. Perhaps days before the person passed away, a son or daughter was in there with the power of attorney. Something seemed awry, something seemed off, and so the bank, to protect that money and to protect the deceased's property and the estate, the bank might send the matter to their head office in Toronto or elsewhere, and out of an abundance of caution, you might have the bank frozen, and you might have to take steps to prove to the court who the executor, the estate trustee of the estate is, before they will unfreeze it. But in the usual course, no, accounts aren't automatically frozen after someone dies, and oftentimes we see, especially in joint accounts, activity in the account after the person passes away. And in fact, a jointly owned bank account often devolves to the other surviving joint account holder by right of survivorship.
Okay, thank you. And just a reminder, we are now after 11, so we do understand if people do need to step away. Thanks to our lawyers and Susan, who will stay with us for a bit to get through some questions. And again, just a reminder, you will get an evaluation when you leave, and a reminder to do that tomorrow. So we do appreciate the feedback, and there will be you will receive notice when the recording is available, plus some of the resources that we've talked about today. So just jumping back into the questions, as a POA for property, and I think we might have covered this, but just maybe touch upon it if not. Am I required to share financial information with family members? I keep detailed records of all transactions and talked to my mother, who has dementia, on a regular basis to keep her up to date.
So I can answer that one. So if the person asking this question is the sole POA, they have no obligation to account to their siblings at all. The only time they have an obligation to account to their siblings is if, or to anyone else, is if the court orders them to do so. Now, to avoid conflict and to avoid litigation, if the attorney doesn't think they've done anything wrong, they can provide an accounting of sorts. But there's also privacy concerns. So if in the Gloria's case, let's say Robin is named as the attorney for property, and we have Catherine and Courtney saying, show us what you've done with mom's property. If the attorney knows she's not done anything wrong, she can redact certain information and she can share that with her sisters, but she's under no obligation to do so.
Okay, thank you. And we might have covered this when we talk about banks. Are there specific forms of power of attorney that you need to show banks to give you power to exercise banking decisions?
So it would have to be the power of attorney for property. So the power of attorney for personal care is not going to authorize you to make banking decisions. It's the power of attorney for property, and it needs to be properly, it needs to meet the legal formalities. So it has to be witnessed by two witnesses who signed it in the presence of the grantor of the document, who are present with each other at the same time. So as long as it meets those requirements and it's clear that it is a power of attorney for property and meets the requirements of the Act, then that should authorize the person to make decisions on behalf of the grantor with respect to the banking. Certainly, there are, Susan mentioned, documents that were prepared by the Ministry of the Attorney General that sort of outline those requirements. They, as they stand, meet those requirements, and they just need to be properly witnessed. Sometimes if the bank sees a homemade document that's not on that format or appears to be something sort of pulled off of another source, they may have questions about the validity of that document.
Okay, thank you. Next question, quite interesting. Can a caregiver named in a will inherit debt if there are no assets?
So I'd be happy to answer this one. So an executor named in a will or a beneficiary in a will, you do not inherit someone's debt. What happens is when a person passes away, if they have debts and liabilities, those debts and liabilities are paid first out of the estate. If the entire estate is used up by paying off those debts and liabilities, and there's nothing to distribute, well, that's just, it is what it is in that case. But no, you do not inherit someone's debt unless, of course, the debt is joint and several, in which case, you know, it's your debt.
Great, thank you. So question, what is the process for transferring the POA to the caregivers if for example, a spouse who currently holds it is making dangerous decisions about the other spouse with dementia?
So I'm happy to answer that. So you can't transfer the POA. This kind of goes back to what Laura and I were discussing, naming perhaps multiple attorneys, naming a substitute attorney in case the primary attorney can't act. So if there's a situation where one of the attorneys is no longer capable of acting, you can either apply to the court for directions, or oftentimes, and Laura might be able to speak to this, in the document itself, there might be a requirement for a statutory declaration that by the substitute attorney that the primary attorney is not capable or willing to act. But the safest, if there is conflict, the safest thing to do would simply be apply to the court for directions and set out the reason why the primary attorney perhaps is not capable or suitable to continue acting.
Anything to add, Laura?
Yeah, I guess if it's possible to have that person have their own capacity assessed, the initial decision maker, then that might be an option too, because usually it will be drafted as that if that person becomes incapable themselves or is unable or unwilling to act, then the substitutes would step in. But to the extent that there's no substitute made, the transfer process would be through a guardianship application to have a new decision maker appointed.
Great, thank you. Very thorough response, thank you. Okay, I think we've done this one already. Someone says, I'm the executor for my father and I have his original will. My sister is asking to see his will. He has Alzheimer's and cannot give permission for this, but she keeps asking him. My understanding is that his will is a private document until his death, at which time the beneficiaries will be notified.
Yeah, absolutely.
And so, and that understanding is absolutely correct. No, you do not have to disclose the will to your sister. It's a privacy matter. And also, you know, there's an obligation not to disclose that will to the sister. We don't know what her intentions might be with that will. And so I would always recommend not sharing the will with the sister. It is important though for an attorney or for a guardian to have a copy of the will of the person's will, simply because they don't want to do anything inconsistent with that person's testamentary wishes, give away property, for example, or sell off property if that piece of property specifically provided for in the will. So always a good idea for the attorney or guardian to have a copy of the person's will on hand, but you do not need to provide a copy of the will to any other siblings, especially while the testator is still living.
Great, thank you. Okay, so my sister took our father to a lawyer to change the POA and terms of his will to make her POA an only beneficiary. He refused, and saying a good day with dementia, and only told us about this later. How do I protect my father? I am worried about this happening again.
Yeah, I mean, it's so tricky. Hopefully, you know, from my perspective in my practice, if one child contacts us out of the blue and is bringing in a person, and that child is being made the only attorney and the sole beneficiary of the will, when we did not do a will initially for that client, I have no relationship with that person, that is a huge red flag for me. And that is going to be a huge red flag for all estate planning lawyers. So it's very difficult to prevent something like that from happening, depending on the living situation and the access that the person who's trying to make those changes has to the person with dementia. But just know that it's the responsibility of every lawyer who does an estate planning document to make sure that their client has capacity and to ask detailed and probing questions, and to not act unless they are satisfied that what the client is doing makes sense and there's no undue influence.
And if I could just add to that, I mean, depending on the degree of conflict you want to create in your life, it's also possible for that sister who received that information from her father, it might be a good idea to paper that, right? Because you could go see a lawyer, or you could write a letter yourself just saying, you know, Dad told me this, that on this date you took him to a lawyer and she or asked him to go see a lawyer and he didn't want to see a lawyer, and put it on paper. Because if in the future sister is successful, let's say it's a bad day, or dad's confused and he succumbs to the influence from daughter, we might have a challenge, a POA challenge or a will challenge. And if you have a letter from a lawyer on hand in advance, it might be a useful tool down the road, in case a new POA or a new will does pop up.
Great, thank you. Okay, so this is a bit of a long one. It might be, so my brother lives with my mother, and the arrangement is that he can live there rent-free as long as he buys groceries and prepares meals for her. He does not provide any other care. He is now asking for payment for this arrangement, equivalent to a full-time living caregiver at market rates. I have POA for property, so he is asking me for money. How should I handle this?
So, I mean, there's a few ways you could handle it. If it's unclear here whether or not mother is incapable. If mother is incapable, then the power of attorney for property would be responsible for making decisions with respect to mom's property and finances. And the power of attorney for personal care would be responsible for matters relating to mom's personal care, nutrition, shelter, safety, healthcare, all those matters. So, I mean, what would be more affordable? What would mom be comfortable with? I mean, I think it would make sense to ask mom. Mom might prefer for brother to live in the house and be providing care, as opposed to you know, a support worker coming in you know, twice or three times a week or multiple times a day. So I would encourage mom's participation in the decision. At the same time, though, you want to make sure that brother's not taking advantage of mom, and you want to make sure that brother's providing the type of care that mom actually needs. Perhaps mom would be receiving better care through the LIN or the VON or whoever's providing the care. So I'd tread carefully with this one. And I mean, if you really want advice, I would say go see a lawyer so you can provide a few more particulars about this specific case. But this sort of thing happens all the time. And what you want to do is you just want to make sure that mom's best interests are being served, and that she's not being taken advantage of financially.
And I would add to that, very great answer as well. If to the extent that that arrangement is going to change and he is going to be being paid for services, then that should be papered as well. So it should be very clearly set out exactly what he's being provided and the services that he is expected to provide. similar to any live-in caregiver who would have a contract in writing about what the pay was and what the services that were expected were.
Great, thank you. So next question, if you maybe clarify a little bit, if a POA is to be challenged, what are the steps to start a court process?
Well, first, meet with a lawyer you're comfortable with and who you think will do a good job for you. And essentially what happens is you commence a court application setting out why the power of attorney should be declared invalid. And if you're not trying to get it declared invalid and you're simply trying to get someone removed, you'll set out in the court materials why that person should be removed. And you're going to need some solid evidence because courts don't like to remove an attorney or declare a document invalid unless it's confident that the document is invalid and or it's confident that the attorney's not doing their job right. The court doesn't like to interfere with people's affairs in that way, especially if when the power of attorney document was executed, the person was capable. The way you do it is you commence a court application.
Thank you. So this one might just be a bit of clarification. So can you please clarify that applying to the court to act on someone's behalf is only for POA for property? For personal care, it would go down to the subject decision maker hierarchy first before having to apply to the court, right?
That's a great question. So the guardian proceeding, so you can be appointed as the guardian of the person of someone or the guardian of property of someone or in both roles. The hierarchy of decisions for the person, that only applies to healthcare related decisions. And that is really kind of a last resort. Like you don't want to rely on that decision-making list because it really only applies to consent to or refusal of treatment. And it's meant to encompass situations where there was no planning done or there's not enough time. It's a quick kind of turnaround situation where a healthcare provider needs instructions and they have a list of people that they can turn to if they can't get that instruction from the person themselves. So I wouldn't rely on that for personal care decisions. It's great to have the power of attorney documents for both in place. To the extent that those are not in place, then there is a court proceeding for an application to be the guardian of property and of the person.
Great, thank you. So a question, where does a do not resuscitate order belong? In a will?
No, so the do not resuscitate order, so that is a personal care matter. Often if someone is entering into long-term care or entering into a hospital, they will be asked to give instructions on a do not resuscitate order, or the substitute decision maker will be asked for that information. The will only is effective after death, so the do not resuscitate instructions, sometimes we find them in the power of attorney for personal care document itself. Sometimes it's a wish that's expressed outside of that. With that, it's important to know, though, that if you're in an emergency health situation and EMS is responding to that, they are always going to resuscitate, even if the person with the power of attorney is standing there saying, I know that this person did not want to be resuscitated. The only way they will not do that is if they're presented with a very specific form that confirms that there is a do not resuscitate order on file with a doctor. And that can be filled out with a family physician.
Great, thank you. And I think this next question might be best for Susan. So I'm sorry if I missed this. What is the best way to work with an elderly parent who needs to be encouraged to get this process started, especially if early dementia already exists?
So thanks for that question. And I suppose my answer from a social work perspective is to really understand what the behavior is trying to communicate from the parent is, and sort of answering those questions as best you can. Is the person with dementia communicating that they're afraid of dying, that they're thinking about loss, they're thinking about grief? So really, where is this coming from? And then addressing those issues as best you can, and sort of joining with the parent and having a very fulsome conversation about what's going on. You can also always enlist your social worker at the Alzheimer's Society to facilitate a family discussion. Sometimes hearing this sort of information from an outside professional is very helpful in terms of getting the process started.
Great, thank you. So question about how long is a capacity assessment valid for?
So, I mean, the capacity assessment, the capacity assessment, I mean, it speaks to the person's capacity at the time the assessment was performed. So again, we might have a situation where someone's being assessed on a Monday morning and they're doing really well. It's a good day for them. And the assessor will say, okay, yeah, you're capable of managing your property and making healthcare decisions and granting and revoking a power of attorney. But, you know, on Friday afternoon, 4 days later, the person doesn't have capacity. So it's not like it's valid for a certain period of time. It just speaks to the person's capacity at that time, and provided that the power of attorney document is executed around that time, or the will is executed around that time, or powers of attorney are revoked around that time or granted. It's a good indication that the person did have capacity around that time. But I would always recommend that as soon as a capacity assessment comes out and it reveals that a person has capacity, you should probably act as quickly as possible to get whatever documents need to get executed.
And if I could just interject for a second, because I do have some experience with that as well. If a person wants to, let's say they were deemed incapable by an official capacity assessor, but they believe that they are now capable, they can actually reapply and have another capacity assessment done. They just have to pay for it. The other thing I just wanted to add a little bit around official capacity assessments is that there's a very small amount of money for subsidies. If you really believe that a person could benefit from an official capacity assessment, but they lack the resources to do so, you can apply for subsidy to have that happen.
Right, that's very helpful. Thank you. So I'm just going to, we're just almost a half an hour over our time, so I'm just going to post a few additional questions. If you have been appointed executor of a will, can you decline, and what happens if you do?
Yes, absolutely. So long as you have not started, so say the person has died and you find out you're the executor in the will, and you have not started acting in that role, so you haven't started representing to other people that you are dealing with the estate, you haven't taken on estate assets, you can simply renounce that position. There's a document that you sign that says, I'm not interested in acting. And then to the extent that the will was drafted with a substitute executor, that would be the person with the right to then carry forward in that role. To the extent that the will was silent to that and there is no substitute, then it's going to fall back usually on the closest family members who have the right to apply to be appointed. They would still be an estate trustee with a will, so they're still bound by the terms of the will and the distribution that's in the will. But they're applying based on the fact that there's nobody left named in the will to be the executor.
And I should also add that if someone does start acting as executor, but something happens down the road that makes them not possible, for example, they might become incapable themselves. If they've already started to act, there will have to be a court proceeding to have a new executor, a new estate trustee appointed.
Great, thank you. So I think our final question, and I know we have not gotten through all of them, but certainly if your question has not been answered, certainly you can reach out to us. You can reach out to, again, our lawyer. We will be sending out some resources after this event. If two named POAs cannot come to a decision, what is the recourse?
I think, John, that would be in your realm,
so
sort of an application for court directions.
Exactly. So this happens often, and this is why, again, it's so important to consider who you're appointing as your attorneys. If you're appointing more than one attorney to act jointly or jointly and severally, and you know they don't get along, probably not a good idea to appoint them. I always say, if being one of 7 boys in my family, if they didn't get along when they were 6 and 7, they might not get along when they're 56 and 57. And we see it all the time in our practice. So when there are two attorneys who are battling or they don't trust each other, and one attorney says, let's put mom into this retirement home, and another attorney says, no, mom can stay home, it's fine. What you're going to have to do if you can't resolve that conflict is you're going to have to go to court. You're going to have to ask for directions. And if the conflict is so significant that it's just not possible for the attorneys to get along, one of the attorneys might consider trying to oust the other by having that attorney removed.
Yeah, I have clients, just to John's point, I have clients who say to me, well, I think that this is the thing that will bring my children together. They historically do not get along, but they will put my best interest first, and this is going to be the thing that unites them. Like 9 times out of 10, 9.9 times out of 10, it's not. It's a very stressful time. It's a lot of work to act under those documents. And to the extent that there's existing tensions in a family, that the illness of a parent or the death of a parent is only going to exacerbate those tensions.
Okay. And actually, someone has commented in the chat that they have actually their lawyer as a substitute POA. So again,
yeah, certainly possible. Most lawyers will only act as a property POA just because they don't have the knowledge of the person to be the personal care. Like, that's my personal preference. And many will charge for those services based on an hourly rate or a percentage. So it's important to have that clarified if you're going to go that route.
Great. So thank you both very much. I'm just going to do a couple of wrap-ups here. So we so appreciate the extra time, and perhaps we'll just take a look at the questions after and see if we can respond to them in another way. So thank you again for joining us, all of you. And just a few final things. We appreciate everyone who joined us today. I know many have already stepped away. And a reminder that you will get a recording with some resources, and we'll include the case. So just a note, our next webinar, and you'll get reminded of this in tomorrow, is The Basics with Dr. Bori, and that's next month on June 15th. So we hope you'll join us. It's always a well-received favorite. And we have a walk coming up, so we just want to say that. So we hope that you can participate in any way and get your steps in, or support the society through other means. And finally, thank you, and you will receive an evaluation. It might pop up in your screen, or you'll get it in a follow-up email tomorrow with an evaluation. So we do appreciate that very much. And to leave the webinar, you can just click the leave button. And we do thank you all again, and have a wonderful day and enjoy this amazing weather.
Thanks, everyone.
Thank you.
Thank you.